The law offices of Affordable Living Trust would like to welcome you to this presentation on reforming an AB trust after the death of the first spouse. In this presentation, we will cover the many reasons why surviving spouses and families should strongly consider seeking judicial relief from their AB trust, and why failure to do so could prove very costly to everyone. Before I begin, a few housekeeping items are necessary. This presentation is only intended to provide general information and education. It should not be construed as forming an attorney-client relationship nor engaging us for legal, tax, or other advice. It's possible that your individual circumstances, non-U.S. citizenship, or changes may make this information inapplicable, and thus no advice or tax advice is being given for any specific transaction. You should always consult an attorney and other professional advisors for any specific transaction and advice appropriate to your individual circumstances. The entire contents of this presentation are copyrighted and may not be used or reproduced in any form without express written permission. Finally, this presentation is not about whether you should have a living trust. That's still very important. The issue is about what type of living trust you should have. More specifically, it's about the many problems associated with the AB trust that so many surviving spouses and their families are living with. So let's begin. My name is Landis Mahaffey, and I'm an attorney with over 30 years' experience with living trusts. As a matter of background, countless married couples in years past were persuaded into signing up for an AB trust because they were told it would save on taxes. While that used to be true, it's rarely true anymore. Yet large numbers of surviving spouses find themselves living with an AB trust. In the past, AB trusts were necessary for making maximum use of both spouses' estate tax exemptions. Thanks to vastly increased exemptions and a 2011 law known as portability, that has changed. In short, the law of portability now allows the survivor to use the deceased spouse's unused exemption without going through the hassles of an AB trust. In 2019, with portability, a surviving spouse can pass up to $22 million tax-free. Even without the benefit of portability, in 2019, a surviving spouse can pass up to $11 million tax-free. This means, from a tax standpoint, the AB trust has become nothing more than a useless and expensive headache that forces the surviving spouse to live with lifetime hassles, restrictions, and exposure to lawsuits, all while no longer resulting in any tax benefit for most. The true irony is that instead of fulfilling the promise to save on taxes, AB trusts now regularly result in more taxes, often hundreds of thousands, even millions of dollars in unnecessary taxes. And here's how. Most of you should be familiar with the $250,000 tax break when you sell your residence. Problem is, that nice tax break doesn't apply to any part of the residence allocated to the B trust. In California, this alone could cost the surviving spouse up to $90,000 in additional taxes when the surviving spouse sells the residence. And it gets worse. Normally, when you inherit an asset, you get the benefit of something called a stepped-up income tax basis. Stated at its most basic level, the stepped-up basis means the IRS ignores all appreciation that occurred before you inherited the asset. Simply put, this allows you to either sell the asset income tax-free upon inheritance, or if you sell it later, you will only pay taxes on the appreciation that occurred after it was inherited. Many regard the stepped-up income tax basis as one of the most generous benefits in the tax code, and it isn't hard to understand given that it allows you to sell the inherited asset while paying little or no income tax. Problem is, this benefit does not apply to assets inherited from a B trust. Let me say that again. Assets inherited from a B trust do not receive the benefit of a stepped-up basis, and this is often the most expensive consequence of the AB trust. In California, for example, it is not uncommon for B trust assets such as real estate or stocks to appreciate $1 million during the surviving spouse's life. If these assets are inherited from the B trust, then sold, it will eventually cost the heirs as much as $400,000 in additional income taxes. In stark contrast, without the AB trust, there would be no additional income taxes due on the $1 million of appreciation. To summarize, the same asset inherited from the B trust will eventually cost the heirs as much as $400,000 in income taxes. Yet without the AB trust, there would be no income taxes due on the $1 million of appreciation. Whatever numbers you choose for your own estimates, the rules remain the same. B trust assets do not receive a stepped-up income tax basis, and it's just another way that the B trust regularly results in more tax. Truth is, there is so much wrong with the AB trust, it's shocking to most. Take, for example, the fact that the financing or refinancing of real estate often becomes near impossible or very expensive. Also take, for example, the numerous cases we have seen where the surviving spouse has been taken to court by their own children and forced to spend tens of thousands of dollars in legal fees, all made possible by the AB trust. Then there are the many other additional duties required by the AB trust, such as dividing up your assets into the A and B trust, filing extra tax returns every year for life, maintaining proper accountings and separate ongoing books for the assets in the A and B trust for life, remaining answerable to the future beneficiaries of the B trust, including the right to demand accountings and bring court actions against you for the rest of your life. While I could go on, these highlight just a few more of the consequences the surviving spouse will be forced to live with for the rest of their lives with an AB trust. These are just some of the reasons we have never met a surviving spouse who liked living with their AB trust. So if you're a surviving spouse, or family to a surviving spouse, or even a professional advisor to a surviving spouse, it is vitally important to check every trust for this issue. If you see words like marital trust, exemption trust, credit shelter trust, bypass trust, etc., this means you probably have an AB trust and should strongly consider initiating a trust reformation process seeking a court order giving surviving spouses and their families relief from the AB trust. The good news is that our law firm has successfully helped numerous clients achieve this equitable relief, often without requiring a court appearance, especially when the children and beneficiaries cooperate. That is why we always ask about family cooperation, because in our experience, surviving spouses who are able to gain the consent of their children tend to face a much easier, obstacle-free path to the AB trust reformation. In truth, children should usually be eager to cooperate, especially since they often stand to benefit the most in the form of a stepped-up basis. Yet at times, we still encounter children or beneficiaries who are resistant to cooperating. They worry about giving the surviving spouse unfettered control, or that the surviving spouse may change the inheritance provisions, perhaps reducing or eliminating their share. While it is true that refusing to consent generally prevents the surviving spouse from making such changes to the B trust, it's also true that the surviving spouse still retains the right to change their portion of the trust. We find survivors usually have no such intent. That is, until they discover a resistant child or beneficiary who won't cooperate or is difficult. And in a perfect example of unintended consequences, that is what often triggers the surviving spouse to make changes to their portion of the trust by either disinheriting the uncooperative children or heavily adjusting their share to compensate for the heavy expense and headache to everyone else. Put another way, their lack of cooperation is what causes the surviving spouse to make changes they otherwise would have never made. It's truly a lesson in how beneficiaries often manage to shoot themselves in the foot. In other words, these uncooperative children literally engage in their own self-defeating conduct, and many times their own zealous lawyers encourage them to do so. Yes, you may have right, but do you really want to upset the person who would otherwise tend to be magnanimous towards you? If the possibility of being disinherited by the survivor isn't enough to motivate cooperation, there are two other alternative paths. One path is to reach agreements with beneficiaries in a way that protects their interest, for which in turn they consent to the reformation. The other path is to file the petition without their consent, force a special hearing, and hope that the judge will grant the reformation anyway. In forcing either of those latter paths, a beneficiary still needs to ponder all the potential negative consequences of upsetting the person who may otherwise tend to be generous towards you. So again, whether you are a surviving spouse, the children of a surviving spouse, or even a professional advisor to a surviving spouse, it is vitally important to check every trust for this issue and take a deep look into the potential benefits and possibilities of going forward with an AB trust reformation. While we find the vast majority are excellent candidates for trust reformation, we also realize everyone's situation is different and should be looked at in greater depth. But I hope what we've discussed here at least motivates everyone to do so. Free of charge at our law office, we are happy to sit down with anyone to analyze and discuss the applicability and appropriateness of an AB reformation to your particular circumstances. We help families with this all the time, and we look forward to helping you. If you would like to schedule this free consultation, you can contact the law offices of Affordable Living Trust at 408-741-1627 or visit our educational website at affordablelivingtrusts.com. Thanks for watching.